Okay, so this is your lesson 15. We are going to talk about evaluation of labor legislation and need for labor code. So what we are going to talk in this chapter is that why do you need labor laws? Okay, you're studying labor laws. So what is the need for labor laws? And there's something called as labor code introduced by our government. So what is it? So that's what we're going to cover in your lesson 15. It is again a continuation from what we've seen in the previous chapter. Previous chapter we spoke about constitution and how it is going to be the guideline, how it is going to be the basis on which labor laws are formed. Now we are seeing why we need labor laws and what is labor code and why we need labor code also. We'll start with the introduction. The law relating to labor and employment in India is primarily known under the broad category of industrial law. Industrialization. What is industrialization?
Shall open up for uh, global business, opening the nation for global
That is globalization. No?
industrialization to do business, to start the industries.
We have you learned about industrial revolution? Yes.
Yes, ma'am.
What happened in industrial revolution? Yes. Industrialization or industrial revolution.
They convert industrialization. Before industrialization, they all mainly focus on agriculture. No?
Yes, exactly.
During
So
during industrialization, they shift from agriculture to producing or manufacturing.
correct. So industrialization or industrial revolution, it was all about earlier we were agrarian oriented economy where we focused mainly or our main source of income was from agriculture. Industry with the advent of industrial revolution, we found out that we can focus more on manufacturing. This moving towards manufacturing is called as industrialization. So industrialization happened in every major economy, and that was one of the key engine to support the economic growth of any country. A plethora of labor laws have been established to ensure elevated health, safety, and welfare of workers, to protect workers against oppressive terms as individual worker is economically weak and has little bargaining power, and to encourage and facilitate workers in the organization to deal with industrial disputes, to enforce social insurance and labor welfare schemes and alike. So, for all reasons and many more reasons which are not even mentioned here, we need lot of labor laws. Reforms in labor laws are an ongoing process to update the legislative system to address the need of the hour so as to make them more effective, flexible, and in sync with the emerging economic and industrial scenario. So, labor laws are going. Labor laws, as they were established in 1948 or 1972, they are not going to work now because today's industrial system, today's economical scenario is all different from when the labor laws were framed. So labor laws, as and when they framed, you cannot still use them today. You need to make changes to them, update them as and when it is needed so that they can keep up with the changes in the economy and also the industrial scenario. For example, let us say you have something called as Maternity Benefits Act. Similarly, today we are in an era where we look at men, that is expectant fathers, they are asking for paternity leave. So where is the provision for that in labor laws? Right. So reforms in labor laws are very, very, they're not a done and dusted thing. They are an ongoing process. You have to update them regularly to keep up with the changing industrial scenario and economical scenario. The second National Commission on Labour has recommended that the existing labour laws should be broadly grouped into 4 or 5 labour codes on functional basis. So labor laws அப்படின்னு எடுத்தீங்கன்னா there are numerous labor laws. Some of them are established by the federal government, some of them are established by the state government, and all of them are relating to certain what can you say, or main subject பொறுத்து n number of laws there. So when you have multiple laws to follow, then there is a confusion, no? So one particular law will have one provision which will be contravened by provision given in another particular law. So to avoid all this confusion and such, the National Commission on Labour, second National Commission on Labour, they came up with a solution. They said split these labor laws into 4 or 5 labor codes on a functional basis. அதாவது அந்த main subject எடுத்துட்டு அந்த basisல you split them into labor codes. And whatever laws relating to that particular subject will come under the labor code. That is, it will be subsumed by that labor code. For example, if your main subject matter is wages, so let the labor code be wages. And whatever labor laws relating to wages have been made, whether by central government or state government, put them all together under that particular labor code on wages. Understood, ma? How labor codes are going to work? Yes. So you have labor code on wages, you have labor code on industrial relations, you have a labor code on social security, welfare and occupation safety, and you have a labor code on health and working conditions. So there are 4 labor codes drafted by the government. So this is done to simplify, amalgamate and rationalize the relevant provisions of existing central labor laws. So if there are, let us say, 5 or 6 labor laws relating to wages itself, all of them will be put together under the labor code with the heading wages. Understood? They'll be subsumed by the labor code.
Yes, ma'am.
Okay, we come to the history of labor laws. The need for better working conditions, the right to organize, and employer demand to limit employee rights in numerous groups and to keep labor costs down, all these led to the development of labor law. When employees band together to demand better pay, or when law imposes expensive requirements like equal opportunity or health and safety standards, employers' cost may rise. Okay, so when you're making labor laws, you're not, or industrial laws, you're not only supposed to look into one side. That is, you're not only supposed to look into the welfare of the laborers, you also need to look from the point of view of the employers. Right? If you give everything that the laborers are demanding, then the employers will be disappointed, and vice versa, right? So you have to manage the expectations of both the parties when you're making labor laws. Trade unions and other worker organizations have the potential to become political forces. Again, this may not be something that companies may like. Therefore, the situation of labor law at any one time is both a result of and a component of conflicts between various interests in the society. The labor movement has been instrumental in enacting of the laws and protecting labor rights in 19th and 20th centuries. Labor rights have been integral to the social and economic development since the Industrial Revolution. So you should not give the total advantage to either party, whether it is the industrialist or whether it is a laborist. So you'll have to find an equilibrium when you're making labor laws. International Labour Organization ILO is one of the first organizations to deal with the labor issues. The ILO was established as an agency of the League of Nations following the Treaty of Versailles, which ended the World War I. So post-war reconstruction and the protection of labor unions occupied the attention of many nations during and immediately after World War I. So even in Great Britain, the Whitley for Commission, a subcommittee of Reconstruction Commission, recommended in its July 1918 final report that industrial councils must be established throughout the world. So ILO was established post World War I, and it is the first organization to deal with labor issues. And since its foundation, India has been a member of ILO. So India is a founder member of ILO, and it has been actively contributing to the evolution of global policy on labor welfare. So ILO came into existence in 1919, and since then India has been a permanent member, and ILO's governing body came into existence in 1922, so India is also a part of the governing body. At present, ILO has 187 members, 187 members, and the unique feature of this organization is that it has a tripartite character. That is, at every level of the organization, there are three people involved in making the decisions. Government are associated with two other social partners, namely workers and employers. So all the three will sit together and then they will discuss and take decisions. Okay, all the parties involved are there. That is, the employers are there, the workers, laborers are there, and also government is there. Together, you can take decisions. So that is a unique feature of ILO. Even after 75 years of independence, approximately 90% of workers in India, they work in unorganized sector. That is, they do not have access to all social security. Total number of workers in our country, both from organized and unorganized sector, is more than 50 crores. Earlier, the working class was entangled in the web of multiple labor legislations. The central government has now taken a revolutionary step in the right direction to provide them freedom in true sense, that is, by codifying 29 laws into 4 codes. So, 29 acts இருக்கு. 29 acts they have simplified and put them just under 4 codes so that workers can easily get security along with respect, health, and other welfare measures with ease. Right? Okay, moving on, we come to your need for bringing in new legislations. Labor is covered under the concurrent list of the Constitution. You already know that. We did this in the previous chapter. You know what is a concurrent list. Therefore, rules governing labor can be passed by both Parliament and state legislature. The resolution of labor disputes, working conditions, social security, and pay. These are all only few labor-related issues that are governed by more than 100 state laws and 40 federal laws according to the central government. So, just for a few issues like working condition, dispute, social security, and pay, you have 100 state laws and 40 laws made by the central government. So many laws means so much confusion. We don't know which law to follow. Okay. And labor reforms, they remained untouched during the economic reforms carried out in 1991. What were the reforms carried out in 1991? What happened in 1991 in India? You know about LPG?
Liberalization.
Yes. Liberalization?
Privatization and globalization.
Yes.
Globalization.
Liberalization, privatization, and globalization. LPG. They were the economic reforms made in 1991. Even when these economic reforms were made, labor reforms were not changed during that process. Okay. So, which means that labor reforms remain untouched from the time in which they were made. They were not being updated along with the growth in economy and industries. The Second National Commission of Labour had submitted its report in 2002, which said that there was a multiplicity of labour laws in India and therefore recommended that at the central level, multiple labour laws should be codified in four or five labour codes, namely industrial relations, wages, social security, safety, and welfare and working conditions. So, in the Anju code, bring all the labour laws made at the central level. This was a recommendation made by the National Commission on Labour in 2002. While discussions were held on it, no serious initiative was taken during this period from 2004 to 2014. Okay, so once GST came in, GST is a one nation, one tax, no? That is the principle behind GST. Many other taxes were subsumed under GST, like sales tax and other local tax, everything became one under GST. So with GST, similarly, labor codes order importance, so it became clear. So government started fast tracking these labor codes and extensive discussions were held before initiation of labor reforms by the Ministry of Labor and Employment. Okay, and what is the policy making process? If you have to implement a new law or if you have to create a new law, how do you do that? Do you know the process behind it?
For what now?
How do you make new
What?
legislation? Today, I think of
To
something.
supply a bill in the
Yes.
parliament,
Mm.
and both the parties are accepted with the majority, then the bill is passed with the president's signature.
Yes, that is one part of the
Yes.
process. Before that, you'll have to make the law, draft the bill, no? How do you do that?
Yes. To draft the bill.
Yes, to draft the bill. Can anybody draft the bill?
No, ma'am.
Who will do the drafting process?
In draft,
How it is done?
drafting.
பார்லிமெண்ட் ஆஃப் ஹவுசஸ் ரெண்டு பேருமே அக்செப்ட் பண்ணாதான் மேம் பில் பாஸ் ஆகும்.
எஸ்மா பார்லிமெண்ட் அக்செப்ட் பண்ணா பில் பாஸ் ஆகும். அதுக்கப்புறம் இட் ஹாஸ் டு கோ டு தி பிரசிடென்ட். பிரசிடென்ட் சைன் பண்ணதுக்கு அப்புறம் இட் வில் பிகம் a law. That is the later part. ஓகே, இன்னைக்கு எனக்கு லேபர் லாஸ்ல சேஞ்ச் பண்ணும் ஆர் இப்படி ஒரு லாவை நான் கிரியேட் பண்ணும் அப்படின்னா who will write the law? Who will be the law maker?
Judges.
Okay, so here a lot of people will be involved. Okay, so basically நீங்க எது பத்தின law make பண்றீங்களோ அது சம்பந்தமான ministry will be involved, and the ministry will then call upon expert on these subject matters. Right, all these people, they will sit, brainstorm together, and they will bring up a draft bill. Okay, this draft bill immediately it will not go to the approval of the parliament. It will not go to the both houses. Lok Sabha, Rajya Sabha ku draft bill உடனே அப்படியே draft ஆன உடனே போகாது. It should be kept for public approval. You should consult with the stakeholders and public. So what they'll do is they'll put it out. They'll put the draft bill out and ask for the general public and stakeholders to read it and give their opinion. Okay, after receiving the public feedback, this feedback will be taken into consideration, based on which any changes which need to be made will be made to the bill. After that only, the draft bill will go to the houses. It will go to the lower house, that is your Lok Sabha. When it is passed in the lower house, it will go to the upper house, that is your Rajya Sabha. When it is passed in the Rajya Sabha also, it will go to the president. And when president signifies his assent, then the bill will now become a law. It will be entered into the Gazette of India, and from a date mentioned, it will be applicable all over India. This is how law is made. Clear? Okay, so this process was applied here also. So discussions were held by the Ministry of Labor and Employment. They made the draft labor codes, and these draft labor codes were uploaded by the ministry on the website, so that all the stakeholders and public can read it and give their feedback. After this, during 2015 to 2019, the ministry organized 9 tripartite discussions in which all central trade union, employees association, and representatives of state governments were invited to give their opinions or suggestions on the labor reforms. All the 4 bills were also examined by parliamentary standing committees, which gave its recommendations to the government. So all this was the process behind the labor code. In order to codify 29 central legislations, the Ministry of Labor and Employment submitted 4 labor code bills in 2019. So after doing all this back-end processes, in 2019, the bills were submitted. While the Code on Wages 2019 was approved by the Parliament, Standing Committee on Labour were tasked with the handling of the 3 other bills. On all 3 bills, Standing Committee delivered its report, and in September 2020, government repealed these bills and enacted the new ones. So 29 acts were repealed. Repeal means removed. In place of them, now there came 4 new labor codes. What are they? Labor Code on Wages, Industrial Relation Code, Social Security Code, Occupational Safety, Health and Working Condition Code. So these were all replaced. These were the replaced codes. So how many laws? 29 labor legislations. You have Code on Wages, you have Industrial Relation Code, you have Social Security Code, Occupational Safety, Health and Working Condition Code. So 4 codes were put in place of 29 acts. What is the purpose of having a labor legislation? Labor legislation that is adapted to the economic and social challenges of the modern world of the work fulfills three crucial roles. What are they? It establishes a legal system that facilitates productive individual and collective employment relationships and therefore a productive economy. Okay. And by providing a framework within which employers, workers, and their representatives can interact with regard to work-related issues, it serves as an important vehicle for achieving harmonious industrial relations based on workplace democracy. So it tells you the framework of how to handle work-related issues. It provides a clear and constant reminder and guarantee of fundamental principle and rights at work. When there are labor laws ensured, which means that there are certain fundamental principles and fundamental rights that you are guaranteed with, and based on which you'll have a broad social acceptance, and it establishes the process through which these principles and rights can be implemented and enforced. So this is the main purpose of labor legislation. This is a 3-point question, so you may get it as a 4-marker. I don't know. Classification of labor laws in India. So existing labor laws நீங்க எப்படி classify பண்றீங்க? On the basis of industrial relations, you have the following: Trade Union Act 1926, Industrial Employment Standing Order Act 1946, Industrial Dispute Act 1947. Similarly, as per wages, you have Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, Working Journalist Fixation of Rates of Wages Act 1958. Similarly, based on working hours, you have so many acts like Factory Act 1948, Mine Act 1952, Plantation Labor Act. You can see n number of acts relating to timing. And then you have laws which relate to equality and empowerment of women, such as Maternity Benefit Act 1961, Equal Remuneration Act 1976, and laws related to deprived and disadvantaged sections of the society. You have Bonded Labor System Abolition Act, Child and Adolescent Labor Prohibition Act, Children Pledging of Labor Act 1933. And you have various acts related to social security, all your compensation, state insurance, provident fund, payment of gratuity, everything will come here, social security la. So you have almost 51 acts listed in your book. இவ்வளவுதான் acts இருக்கா அப்படின்னா இல்ல. There are multiple state acts also. So many acts are there which to follow. What are so many regulations to be considered? So this creates a lot of confusion for employees as well as employers. That is why you have new labor codes. For the sake of clarity, standardization in terminology, and consistency in approach, the Commission emphasized the necessity to streamline and unify labor legislation. That is the main purpose, for the sake of clarity and standardization in terminology. So you need to have a unified labor legislation. Consolidating labor laws would also enable more comprehensive labor coverage because separate labor laws apply to different employment classifications and across different thresholds. So here also we can see you have separate acts for cine workers, you have separate acts for BD workers, you have separate acts for iron ore mines, right? So many different laws for specific employment classifications. When you codify them, when you bring them all under one roof, you consolidate them, it will be easier to cover employments which are not mentioned by specific acts also. You can comprehensively cover more laborers from different classifications. The 4 codes on wages, industrial relations, social security, and occupational safety were introduced in Parliament as a result of the National Labour Committee's recommendations. While the codes do a good job of combining and streamlining existing legislation, there are still areas in which they fall short. Okay, for example, the codes on social security and occupational safety continue to include specific provisions from each of the statutes. So when they tried to consolidate the different specific acts, they did not remove certain special provisions available for specific employments. For example, still sales promotion staff continue to be entitled additional leave entitlements such as earned medical leave for 1/18th of the period on duty, which is not applicable to any other employment. So particular rules are still there. It is not made common for all employments. Similar to this, even definitions of various terms are not consistent in various acts. For example, the word contract, it is defined in contractor, it is defined in one way in Code of Wages, Occupational Safety and Social Security, but the term contractor is defined differently in Code on Industrial Relations. Okay, so there is no consistency in the definition of various terms in the acts also, even after they are made into codes. And finally, after much discussions, out of so many existing laws, they were only able to codify 29 laws. Again, which means that remaining laws remain unconsolidated. They remain as it is. So that is also a shortcoming of your new labor code. Facilitating employment development while preserving employees' rights is a main problem of labor reforms. The coverage of small businesses, choosing cutoff points for prior approval of layoffs, bolstering labor enforcement, enabling flexible forms of labor, and supporting collective bargaining are important topics of discussion when you talk about labor codes. In addition, as time goes on, it is necessary to update and simplify labor laws in order to include clauses that can accommodate new kinds of employment, especially gig work. What is gig work?
Hello, ma'am.
What is gig work?
Ma'am, hello. You're not audible, ma'am.
Can you hear me now? When did I stop being audible?
The coverage of small business, the point, the coverage of small choosing cutoff. The last line, ma'am. 384, last line.
This one, yeah. I got scared. I've been talking without you guys hearing me for a long time. The coverage of small businesses, choosing cutoff points for prior approval of layoffs, bolstering labor enforcement, enabling flexible forms of labor, and even supporting collective bargaining. These are all some important topics which should be covered by labor code. Okay, and most importantly, as time goes on, it is necessary for labor code to be updated and the labor laws to be simplified and also to include clauses to accommodate new types of employment. When you talk about new types of employment, the most common one that you have to include right now is gig work. I asked you, what do you mean by gig work?
Gig work, mm, part-time work, freelancing,
Yes, exactly. Freelancing. What is freelancing, ma'am? Can you
outsourcing.
elaborate?
Freelancing is a person who has a particular skill and who develop this particular skill and wish to work as a freelance to improve his skill or mm, for the experience, he may do the job as a freelancing or out freelancing, the short
Okay.
term.
Everything is fine. What do you mean when you work as a freelancer? Freelancing means?
Freelancing. We are not an employee
Exactly. You
while
do not
working.
tie yourself to a particular employer or a particular organization. Right? You
Yes,
provide your skills to whoever is in requirement of your skills. Right?
yes,
For
yes.
example, me, if I, as a faculty, if I'm part of a particular institute or if I'm part of a particular university, then I am an employee. Right? But if I teach in various institutes, if I teach or if I facilitate various groups of students, then I am doing freelancing. My skills are not attached to any particular employer or any particular organization. That is called as freelancing. Okay, so freelancing is becoming increasingly popular in today's world, right? So under this also people are working. So what are the labor laws relating to freelancing? How do you protect the rights of a person who is working as a freelancer? That also should be considered in labor laws. That is an example. Apart from freelancing, there may be many other things also should be considered with the growing economy and growing industrial changes. So what the point being made is that once you make laws, you cannot sit simply saying that, okay, job is done, law is created, now everybody will follow the rules and regulations. No, it does not work like that. People are evolving, society is evolving along with the people. the work is evolving. So the laws covering the work also should evolve, is the point, right?
Okay.
Okay. Next, we come to the features of new labor codes. Most labor rules are applicable to businesses larger than a particular size. Okay, so it may be having a threshold like இத்தனை number of employees இருக்கணும் or இவ்வளோ பெரிய organization இருக்கணும் இல்லை இதுல இவ்வளோ அவங்களுக்கு income இருக்கணும் turnover இருக்கணும் something like that. So usually labor laws are applicable to businesses which are of a particular size. Thresholds based on company size could ease the burden of compliance for businesses, but one would counter that all businesses should be subject to fundamental protection, including pay, social security, and working conditions. Such size-based limits are still present in some codes. So just because a person is not working in a big MNC or is not working in a organized sector, can you deprive him of fundamental protections like pay, social security, and working conditions? Did you get the question?
No, ma'am.
Yes. For example, after completing your CS, you guys will go on and work in big MNCs, right? அங்க கண்டிப்பா இந்த லேபர் லாஸ் இந்த ரூல்ஸ் எல்லாம் applicable இருக்கும். So you will be given the fundamental protection of equal pay, you have the protection of good working conditions, social security, இது எல்லாமே உங்களுக்கு guaranteed கிடைக்கும்.
Yes, ma'am.
ஏன்னா labor laws are applicable to big businesses. ஜஸ்ட் பிகாஸ் ஒரு பர்சன் உங்களை மாதிரி குவாலிஃபைடா இல்ல உங்களை மாதிரி ஆர்கனைஸ் செக்டார்ல ஒர்க் பண்ணுன்றதுனால அவருக்கு ஈக்குவல் பே சோஷியல் செக்யூரிட்டி ஒர்க் குட் ஒர்க்கிங் கண்டிஷன்ஸ் கிடைக்காம இருக்கிறது சரியா?
No, ma'am.
சரி இல்ல. சோ லேபர் கோட்ஸ்ன்றது should apply to all businesses. ஆனா இங்க சர்டன் பிசினஸஸ்க்கு தான் அப்ளை ஆகுதுன்னு சொல்றாங்க அண்ட் சர்டன் பிசினஸஸ்க்கு அது அப்ளை ஆகுறதும் ஒரு விதத்துல சரின்னு சொல்றாங்க. ஏன்னா when you put in lot of labor legislations அப்படின்னா ஒரு ஆக்ட் வந்து நீங்க அப்ளிகபிள் பண்றீங்க அப்படின்னா you are increasing the compliance for the business. ஒரு அன்ஆர்கனைஸ் செக்டார்ல இருக்கிறவங்களால இவ்வளோ கம்ப்ளைண்ட்ஸ் பண்ண முடியுமா, லீகல் கம்ப்ளைண்ட்ஸ்னா அவங்களால புரிஞ்சுக்க முடியுமா அப்படின்ற விஷயத்தையும் யோசிக்கணும். So we will have to bring in an equilibrium. We have to provide fundamental rights to the employees. At the same time, we should not overburden compliance on very small businesses.
Okay.
So that is one thing. Next thing is simple and accountable system will simplify the processes. One registration, one license, single return for all the codes. So how do you do that? How do you reduce compliances? Simple and accountable system. So if you get one registration or one license, it will be applicable for all the codes. அப்படின்ற மாதிரி நீங்க legislation process simplify பண்ணிட்டீங்க அப்படின்னா then everybody will be able to easily comply, whether you are a small business or a large business. Right? Next
These
thing
are
is what more?
These things are currently happening, ma'am. Like small
Yes,
businesses also
your
should manage
new
this.
labor new labor codes want to bring all this into existence.
But
Earlier
it's
இல்ல,
not still passed.
they're trying to implement it.
Okay, okay.
Mm.
Yes, ma'am.
So they want this to be the characteristics of new labor code.
Okay, ma'am.
Government approval is required for establishments that employ 100 or more employees to close, lay off, or retrench. So if you are having more than 100 employees, then if you want to close the business, if you want to lay off people, if you want to retrench, partially lay off people, then you need government approval. Okay, so with this restriction, you are very severely putting businesses under a strict demand. Okay, so what happened here is they asked to increase this number. So instead of 100, now the number is increased to 300. So if you have 300 employees, then if you want to close or lay off, you need government approval as per Industrial Relations Code. Okay, and this number is subject to change whenever government wants to. It can do that by notification. Next point, the complexity of labor laws has led to many compliances, which has increased the burden of compliance on the business. On the other side, labor enforcement apparatus has been unsuccessful due to weak enforcement, insufficient sanctions, inspectors, rent-seeking behavior. some of these issues are covered by the codes. So there are both sides. Number one, by imposing so much labor laws, you are increasing compliance in the business, which is hard. At the same time, even after imposing so much labor laws, it has still been unsuccessful because enforcement is weak. So there are insufficient sanctions being made, and the person who's checking whether the labor laws are being in place, they are very corrupt. Okay, so some of these issues are currently covered by the courts.
Okay.
Next is your fifth point. Contract labor is now used more frequently as a result of economic factors and labor compliance requirements. However, fundamental rights like guaranteed salaries have been denied to contract workers. So permanent workers இல்லாம temporary contract work பண்றாங்க அப்படின்னா அவங்களுக்கு கொடுக்கிற rights including guaranteed salary வந்து அவங்களுக்கு கிடைக்கிறது இல்ல. These issues are not entirely addressed by the courts. Fixed term employment, however, is a new type of short term labor that is introduced by the Industrial Relations Code. For example, contract work இல்லாம when you enter into employment itself, employment is for a particular period அப்படின்னு சொல்லி நீங்க கான்ட்ராக்ட் பண்ணிட்டீங்கன்னா இட்ஸ் கால்ட் அஸ் ஃபிக்ஸ் டேர்ம் எம்ப்ளாய்மெண்ட். இந்த ஃபிக்ஸ் டேர்ம் எம்ப்ளாய்மெண்ட் பத்தின பாயிண்ட்ஸ் வந்து இண்டஸ்ட்ரியல் ரிலேஷன்ஸ் கோட்ல கவர் பண்ணிருக்காங்க.
Okay.
Okay. We'll stop with this 6 point. We'll start in the fresh meeting. Okay.